Hi, my name is Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law issues here in Michigan. And today we continue our video series designed to educate and inform the public, so please subscribe to our channel. A lot of times, people have a parenting time arrangement already set up. And the arrangement could look like different kinds of things. The arrangement might be, for example, Monday, Wednesday, and Friday with mom, Tuesday, Thursday, and Sunday with dad. Or it could be alternating weekends or alternating holidays. Some kind of arrangement that they have that starts the process of the parenting time so that both parents have the opportunity to spend time with their children. Every now and then, though, the judgment of divorce starts out a parenting time arrangement, but for whatever reason, as time goes on, the arrangement needs tweaking. Maybe, for example, the parties got divorced when the children were infants, so a more modest parenting time order was put in place, but now it's been a few years. Kids are older. Kids can more readily come to mom's house or dad's house for that matter. And so a different kind of arrangement is acceptable and is something that should be considered. How do you do it? Well, number one, if you have a lawyer, you should contact your lawyer. If you don't, you should get one. And you should tell them, I seek to modify the parenting time order so that I can get more time with my kids. How do we do it? The lawyer will explain to you that you got to file motions. It's great if the other side agrees, and if they agree right off the bat, you kind of save a step because you still need a court order that authorizes it in order for it to be enforceable. But either way, either if you have to file a motion or you can skip that and go straight to an order, you've got to get the court to order that the parenting time is expanded. It's going to affect things. It's going to affect your ability to enforce such an order, to enforce such an arrangement. Therefore, you need a court order. Plus, it may also impact the child support. If, for example, the modification causes the child to spend more overnights with dad, that's going to impact in a downward nature the child support that exists, assuming all else is the same. So, you've got to get a court order because there's got to be things in place. If you cannot agree, then your lawyer is going to file a motion to modify the parenting time. In most cases, we'll first go before the friend of the court in front of a judicial functionary with the friend of the court, and they're going to hear the arguments, pro and con, and then they're going to make a recommendation. The recommendation might become a final order if the parties sign off on it or if nobody objects, but if the parties object, if the parties don't like what the friend of the court comes with, then it goes before the judge. If your ex filed a motion for more time with your kid and you don't like that, you'll get an opportunity to tell the court why you don't like that. But understand one thing. You've got to show that there's a legitimate reason to deny the other parent more time. You know, we live in a world where a lot of times with deadbeat dads and deadbeat parents, people are looking for less time with their kids. So if you've got a parent who's saying, I want more time with my kid, the court is going to be very favorably disposed toward that request. You're going to have to come out with a very compelling reason why that request should be denied. It could be that there's a reason to deny it. Maybe your wife is a drug addict and alcoholic, and therefore you don't want more time, you want to limit the time. Maybe that's what it is. But absent some very strong finding, understand one thing. The court is likely to say, you know what? It's a good idea. Have the child have a little bit more time with one parent than the other. Let's equalize it a little bit. Let the child influenced by both parents. So if you don't want that, you're going to have to find some compelling reason why the court shouldn't honor that request. If you have any questions about that, reach out, and we'll be glad to help you out.